Well, good morning, Belal. How you doing?
Good morning, Greg. I'm good. How are you doing?
I'm hanging in there, man. I am moderately awake. We're kicking this off, so if this is if you're watching this wherever you are, we are just figuring out the Facebook Live thing. It's not so much about the presentation, so much it is about the information, of which Belal has plenty to impart on a Saturday morning. So we're going to get right to your questions here, the ones you passed along. Okay, so here's a question, Bilal. I think this is a good one. If I have a pre-existing injury from a car accident, is it still possible to get workers' compensation if I aggravated that injury?
Good morning, everybody. Before I answer the question, I'd like to thank you for joining us here on Facebook Live on a Saturday. Um, Hopefully, we'll help you enjoy your cup of coffee and your breakfast. Maybe learn a few things together about work injuries. Especially important now because so many people are getting back to work, and we protected ourselves by not working. A lot of us, we've been thankfully running smoothly during COVID, but a lot of people have protected themselves by not working. And now we have to know how to protect ourselves when we're at work, if we sustain an injury. So with that, we'll go through that first question that came in, whether workers' comp can cover an injury that was already previously injured. Yes, the answer is yes. And to best illustrate it, I'll just give you an example. If somebody has a back injury from a car accident, and then at work a few months later or a year later, they lifted a heavy box and because of that they aggravated their back injury. As long as you can show that your work injury contributed to your current back pain, then workers' compensation is on the hook for the medical treatment for that back and also for any permanent disability that arose out of it. So in workers' comp, if you prove that your back was 1% injured from work, workers' comp is 100% responsible for that treatment. So say, for example, you had a 2 millimeter disc protrusion in your back, and then you had a back injury at work, and it's still 2 millimeters, but your work incident contributed to your current back pain. Workers' comp has to now take over the medical treatment for that 2 millimeter disc protrusion. So it's a law that's very favorable to employees. Now there is, for the permanent disability value of the case, we do apportion what percentage of the permanent disability is due to work and what percentage of the permanent disability is due to the car crash, and then you reduce that value. But the most significant value in workers' comp is the settlement that you get when you close out medical treatment, and workers' comp is 100% responsible for the medical treatment value. So if you aggravate a prior injury at work, then yes, you are entitled to workers' comp.
That's a very thorough answer, and that analogy was illustrative too, because that lets people know the specific things. That leads right into the second question that comes in, which is something, frankly, as someone that's been talking to you, I was sort of wondering myself, what does a person do if their employer doesn't have workers' compensation insurance?
Right. So the law does provide in California that every employer has to carry workers' compensation insurance. It's insurance that covers the employees of the company should they have sustained an injury at work, and it provides them with workers' compensation benefits. Now, unfortunately, not everybody follows the law. So there are a lot of companies, especially smaller companies, that do not carry workers' compensation insurance. If you do work for somebody that does not have workers' comp insurance, however, there is something called the Uninsured Employers Fund, which we refer to as UEF. It's a fund created by the state of California. Part of the taxes that we pay go to that fund, and that entity basically steps into the shoes of what the workers' compensation insurance would have been, and they act as the workers' compensation insurance. They have attorneys, they have adjusters, They treat the claim the same way as a workers' comp insurance would have. And then at the end, when you get a settlement with them, they go after the employer in superior court and they sue them for reimbursement. So just so that there's no hiccup trying to get the employer to agree to pay, they step in immediately, they pay, and then the fallout and getting reimbursed, that happens between UEF and the employer at a later time, and it doesn't have anything to do with the employee. It is a difficult process, however, to get UEF joined in the case. The employer has to be personally served with a special notice of application, and a lot of times they are difficult to be found or are very evasive and they don't get served. So the process of even getting UEF joined can take months. And generally, those are reserved for more severe cases because it is kind of a more extreme measure to collect workers' compensation benefits. But if you work for someone and you've sustained a severe injury and they don't have workers' comp insurance, just call an attorney who is familiar with joining UEF. We do that all the time to get your workers' comp claim started.
No, that's a great answer. That answered that good. That lets them know that, hey, there's an option out here for when, this goes bad. Another question that boy, this seems like a good one. Can I use my own doctor in workers' compensation?
Yeah, so a lot of people like to use their own doctors because they're familiar with them, they have experience
Oh,
with
for
them.
sure.
They are already aware of the conditions that they have. You don't have to start from scratch. A lot of times with doctors, it's a process just to figure out what's going on with you. And then if you have to start something new, it's inconvenient, it's uncomfortable. So the question is whether you have to use a workers' comp doctor. If you have an accepted claim in workers' comp, meaning that the workers' comp insurance is accepting this is a work injury and we're going to be responsible for the treatment, then unfortunately you do have to treat within the workers' comp network. It's the medical provider network. These doctors are not employed by the workers' comp insurance. They're just authorized to provide treatment through workers' comp. Just like in an HMO, there's doctors in the HMO network that are authorized. They don't work for the HMO. It's just they're vetted and the HMO thinks that they are credible doctors and they're willing to authorize their treatment. So if you want to get, for example, temporary disability payments, if the doctor's opinion is that you're unable to work, then you may sit at home without working and collect disability payments. But that medical opinion of being unable to work has to be from a workers' comp approved doctor, or else the insurance company will not honor that off work note. So if you go see your own doctor, you're going to be, selling yourself short. You're not going to be able to get all the disability benefits you're entitled to. However, if the claim is denied and the workers' comp doesn't want to pick up benefits initially, you can see your own doctor, and then your own doctor can place you off work and apply for state disability for you from the Employment Development Department, also known as EDD. So in a denied claim situation, you can see your own doctor. So it kind of just depends on the situation. And then to make it even more complex, some body parts can be accepted and some body parts can be denied.
Oh,
so for example, if you're claiming injuries to your back and neck, they may find that, yes, we accepted the back, but we're denying the neck. So what we do is we have the client treat within the workers' comp network for the accepted body part. And then for the denied body part, we actually send them out to a doctor outside of the medical provider network. So it puts the client in a position where they're seeing multiple doctors, one for denied body parts and one for accepted body parts. So that answers the question of whether you can see your own doctor. I would say it depends if the claim is accepted or denied. For accepted body parts, you have to see the workers' comp approved doctor. For denied body parts, you can see your own doctor.
Yeah, but like you said, the sheer complexity of that just says to me, if you're hurt, reach out to an attorney. I mean, every part of that was just so opaque. But I love the analogy about dealing with the HMO, dealing with the health insurance. That's something. Once you said that, I was like, oh, okay, I understand the parameters of this. I totally get that. The next question coming in feels like this is a popularly asked question. One I imagine a few folks are wondering out there: how much do I get paid when I'm on workers' compensation?
Right. So in order to be on workers' compensation, temporary disability benefits, the doctor has to have the opinion that you are unable to work for a certain period of time, or give you a work restriction that the employer is unable to accommodate. In each of those situations, you're at home not working. If the doctor says you cannot work at all, or if the doctor gives you a work restriction like no lifting more than 5 pounds, you go to your employer, you say, hey, can you accommodate my work restriction? If they say no, then you're unable to work and you're in the same situation, you're at home. And the amount of money that you receive is 2/3 of your average weekly earning. So your average weekly earning is taken from the 52-week period prior to your date of injury. So the 52 weeks represents 1 year. So 1 year prior to the date of injury, you divide the total amount of money that you made, you divide it by 52 weeks, and then that represents your average weekly earning. You then multiply that average weekly earning by 2/3. So you multiply it by 2, then you divide it by 3, and then that amount is your temporary disability rate. There are minimums and maximums for temporary disability rates. However, the maximum, it changes every year because of the cost of living expense. Every year it gets more expensive. So it's unfair to keep the maximum temporary disability rate at the same rate every year. So now it's around like $1,100. And then there's also a minimum, which is around a couple $100. And then these numbers, the specific numbers, according to the date of injury, are available online on the Department of Industrial Relations website. They have a spreadsheet there with the dates of injuries, 2015, 2016, up to 2020. And then they tell you the minimum and the maximum temporary disability rate. So if you are working a part-time job making $100 a week, 2/3 of that would be like $67. But there's a minimum temporary disability rate which exceeds that. So there are situations where you can actually collect more money in temporary disability than you were earning at your job, although that's uncommon. So just a short answer to the question, that the temporary disability rate is 2/3 of your average weekly earning.
Okay, that seems like a good, general kind of base. And like you said, everything's different off of that. Those individual cases, Speaking of individual cases, the last question we were sent in, and this was another one that I myself was kind of wondering: can I collect workers' compensation if the accident that injured me was my fault?
Yeah, that's a great question. A lot of people, when they get injured, they report the injury to their employer, and then the employer is like, you know what? We're not responsible for this because it was your fault.
Oh,
you used the
geez.
ladder incorrectly. You didn't use the proper technique carrying the box. They somehow try to blame the employee, but they're not trained in workers' comp, these supervisors in these companies. Some of them don't know that workers' compensation is a no-fault system. That means it doesn't matter whose fault the work accident was. If the employee, negligently injured themselves because they failed to follow proper safety procedures, it doesn't matter. It's not like a car accident where you have to prove that the person who rear-ended you was at fault or the person who T-boned you was at fault. That's a threshold because it's a fault system. Compensation is based on who's at fault in a third-party car accident case. In a workers' compensation case, it's a no-fault system. So even if the employee negligently hurt themselves, they're still entitled to workers' comp. I actually spoke to a potential client about this yesterday, where the employer didn't want to send this potential client to the workers' comp doctor because they said that the accident was the employee's fault. So we intend on assisting that potential client into becoming getting workers' compensation benefits. There is a couple exceptions to the no-fault system. If you're found to be intoxicated at work and due to the intoxication you got injured, then you are not entitled to workers' comp. Another obvious exception is if you intentionally hurt yourself. So if you're intentionally falling on the ground or, hitting your head on the wall, you cannot collect workers' compensation. That would be a fraudulent claim. But in general, even if the work accident was your fault, you still can collect workers' comp. It's very rare to see that a work injury was because of intoxication or because it was intentionally done.
No, that makes sense. That I'm so glad you said that. That seems like that's an obvious misconception that anyone could have. I mean, I certainly did, but it's so the message is, hey, if you're injured at work, you have a claim. I mean, unless the very rare circumstances, like you said. Well, that's the questions we've got here. Is there anything else that you wanted to add, or something that you wanted to tell the folks there below?
Well, I wanted to thank everyone for joining. And, I'm trying to do my best to just educate the community with what I've learned as an attorney. I didn't know anything about workers' compensation, prior to becoming an attorney. I thought it was called workman's comp the whole time. And most people still think that's what it's called. And
I have.
I think California is such an employee-friendly state.
Mm.
There's so many benefits to be provided to California employees with workers' compensation. And I just want to make sure the community is educated and I want to share my knowledge. We are going to do our best to do the live podcast every couple weeks. Um, and then we'll continue to answer more questions. And I also encourage listeners, either prior to the podcast, you can leave a comment on our Belal Hamideh Law Facebook page with your question. We will get a notification of the question, we'll save it, and then we'll answer it live on Facebook. Also, we are looking at the notifications and comments live as well. So we're kind of multitasking. I'm looking at the screen, looking at the notification.
There's a lot going on.
And I want to try to answer the live questions as well. So I wanted to thank you, Greg, for being a part of the podcast.
Of course.
And helping facilitate the questions. And I want to thank everyone who's joined at home. God bless, and everyone enjoy your weekend.
All right. Take it easy. Have a good weekend, everyone. Bye.